Hey guys, TheRealLauraB's back. I thought I would share some of what's going on in New York with the ACLU. So they filed, it's a long case. I'll show you the list. They want their money. They want to be reimbursed from Johnny Depp for $86,000 for expenses they claim. And we have Johnny's answer. So let's get to that. Hi, I'm Laura, also known as TheRealLauraB from Twitter. I'm a researcher, truth seeker, and a new wave internet journalist. I'm not a lawyer, nor offering any legal advice. Join me on a journey to draw the curtain back to expose key news developments in the world of celebrity lawsuits and current events. Let's get started. Hey, so let's start off with what was going on in New York City with the ACLU to start with. So let's bring them up. All right, so let's go over here. Maybe this a little bit bigger. So this is where it's filed. This is the e-courts for New York City. It was started May 10th of 2021. You're going to see everything Johnny's team had to file. Jessica Myers is lead on this one, and just document after document after document just to file their original claim motion to compel the ACLU to comply with the subpoenas they'd issued. They wanted documents and they wanted some depositions. So they get all the way down to 39 documents they filed to start with. And then we're going to get down, the ACL opposes it. We're not going to go through all these, but I just wanted to see how many documents have been involved. A lot of lawyer hours for both sides, And then we're going to get down to the end where Mr. Schwartz, he's left his company, his practice. So that's not a big deal. So let's get into their claim to start with. This should be the first one. Yeah. So it's very simple. Simply, ACL's filed this. They're the respondent. And the memorandum of law support, which we're going to follow, is they're claiming two rules, saying that we should be reimbursed for our expenses. So we have here Rule 3122 regarding the subpoena, paragraph D. If it directs the production of original documents for inspection and copying at the place where such items are usually maintained, it shall be sufficient for the custodian or other qualified person to deliver complete and accurate copies of the items to be produced. The reasonable production expenses of a non-party witness shall be defrayed by the party seeking discovery. So again, these are the documents they're saying that they should get reimbursed for. And this one, 3111, production of things at the examination. And this would be the notice of subpoena may require the production of books, papers, and other things in the possession, custody, or control of the person to be examined to be marked as exhibits and used on the examination. That would be for the deposition. The reasonable production expenses of a non-party witness shall be defrayed by the party seeking discovery. So these are the rules. Now, there's nothing in here about lawyers' hours. So let's see what they're trying to claim. So this is ACL's lawyer. They're the respondent. They are saying that per Mr. Depp's request for Depp document and subpoenas, that this proceeding arises from the case Depp versus Heard. The Virginia action was brought by Johnny against Ms. Heard, and the ACLU was subpoenaed. The op-ed discusses the reluctance of survivors of domestic abuse rights. So this is regarding her op-ed that the ACLU helped promote. The op-ed discusses the reluctance of survivors of domestic abuse to report their experience, the Me Too movement, and legislative efforts related to women's rights. So in early 2021, Mr. Depp served 6 subpoenas at the ACLU who are all non-parties, because they're non-parties is where they claim these rules come into. So they submitted the 6 subpoenas. The ACLU served written responses and objections in which they indicated they intended to seek reimbursement for the production expenses. These written responses and objections were previously submitted in prior motions. It's consistent with their written responses and objections. The ACLU non-parties initially agreed to conduct a targeted collection of documents that concerned the approval, conception, preparation, and publication of the op-ed. Mr. Depp did not agree to accept this compromise and in satisfaction of the subpoenas. Now remember, they came back with all this compromise. They went back to the judge, and the judge said, no, you're going to do everything Mr. Depp asked you to do. There was 24 points. Johnny was approved out of 23 points. The one he didn't get was how and why Miss Amber Heard was appointed ambassador and what her role is. So nothing about the ambassador part, but everything else he won. So they came back and said, hey, we don't like this. We want to change this. We want to get our executive, Mr. Romero, to not have to, Anthony Romero, to not have to give a deposition. And the judge disagreed with that. So for them to say they were trying to compromise, the judge was very clear. And you see all those legal hours that had to do this. You need to comply with all these subpoenas. And that happened on July 22nd. The court granted, in part, 23 out of 24 requests that they would have to comply. So on March 2021, the ACLU non-parties conducted a targeted collection of documents concerning the approval, conception, preparation, and publishing of the op-ed. Everything was limited to the op-ed. And they had attorneys and technical staff working under my supervision. This is the woman who's found the paperwork. Conducted a document collection limited to the custodians most directly involved in the preparation of the op-ed. And they limited to a 3-month period. And the collection and review process yielded 500 responsive documents. The ACLU non-parties incurred less than $10,000 in outside counsel fees and costs to conduct this targeted search. In August through October 2021, the ACLU conducted an additional broader document collection and review consistent with the court's order. This document collection used data parameters covering the times between 2016 through the date of the collection as called for in Mr. Depp's subpoenas. So it seems to me they should have done it the right way the first time. The collection included additional documents custodians most likely have documents responsive to each of Mr. Depp's document requests, including employees in the ACLU's development and communications departments in order to identify responsive documents. This collection used broader search terms than the March 2021 collection. So they were already trying to limit what they were doing everything they could to limit what they were going to give Johnny information-wise. In order to identify responsive documents, the collection used broader search terms, which returned a materially higher number of documents with a higher proportion of non-responsive documents, increasing attorney review time. So they have the attorneys reviewing every one of these documents as though they're part of the case, as though they are a party of the case. During the second document review, significant attorney time was required to review responsive documents for privilege and to prepare a privilege log. This was primarily a consequence of Mr. Depp's requests that sought information about the pending Virginia action itself. The search terms used to identify responsive documents also returned many communications with in-house and outside counsel. So they're claiming privilege of those. While the document review occurred in 2 phases, attorneys working under my supervision tailored the search parameters used in second phase to avoid re-reviewing documents that had been collected the first round. The total attorneys working under my supervision reviewed over 7,500 documents and prepared 1,909 responsive documents for production spanning over 7,000 pages, along with assorted metadata. The ACLU also produced Mr. Wisner and Mr. Romero and a corporate representative for depositions in response to Mr. Depp's 3 subpoenas. And we had the corporate representative appear at the trial. Mr. Depp took over 16 hours of testimony from these witnesses, over 4 hours for Mr. Wisner, 7 hours for ACL's corporate representative, and 5 hours for Mr. Romero. The ACLU's production expenses they seek over $85,000 in fees and $1,000 in costs for documents. The ACL non-parties seek reimbursement for time billed by senior associate, junior associate, litigation support program manager, and a litigation support analyst. I supervised all the work and conducted in this matter. A detailed description of the billing entries will be following. You can correct copies of the profiles. We don't need to see those, of who these people are, and the 2 technical staff. And here's the breakdown. They charge an hourly rate. So they broke down their hours, and this is how much they charge per hour for a senior associate, a junior associate, and litigation support. I would like to make that much an hour at this level. From my experience as a partner of Patterson Belknap, I understand that the hourly billing rate for Patterson Belknap's attorneys and staff are consistent with the rates charged to clients like the ACLU. The ACLU non-parties do not seek reimbursement for outside counsel's time spent conferring about document collection and review activities internally with the ACLU employees, which totaled over $15,000. So give them a $15,000 break there. ACLU non-parties also do not seek reimbursement for other tasks related to the document subpoenas, such as preparing written responses and objections to the subpoenas, meet and confer discussions with Mr. Depp's counsel, and motion practice. In addition, the ACLU does not seek reimbursement for the considerable time its own personnel spent searching for and collecting documents in-house without using a vendor and in assisting outside counsel in complying with the subpoenas. The ACLU do not seek reimbursement for any costs associated for preparing for the 3 depositions. The ACLU incurred over $1,000 in cost connection with the subpoenas themselves. This is the actual document production. Prior to this motion, the ACLU sent a detailed description of the production costs to Mr. Depp and sought to negotiate reimbursement without court intervention. So let's look at the little chart that they used. So here we have broken down, this is the rate. And so pretty much it's all legal hours, lawyers, billable hours that comes to the $85,000. So you see what they're all doing and how many hours each person put in. So Jessica Myers, who we saw in the trial, prepared this. And we have the background, the argument, and the conclusion, and the cases they cite. Respondents, which is ACLU, request for excess of $86,000 in expenses, quote, associated with their court-ordered document production is not only exorbitant and unreasonable, but unsupported by New York law. Mr. Depp acknowledges that New York law provides for the reimbursement of reasonable production expenses to a non-party and does not oppose reimbursing the respondents for such reasonable expenses. But respondents seek reimbursement for expenses that go far beyond what was reasonably required to comply with the subpoena Mr. Depp served upon ACLU. Quite simply, New York is clear that Mr. Depp is not required to reimburse ACLU for attorney's fees associated with the time spent determining what documents to withhold from the production based on privilege or relevancy. Indeed, even Mr. Depp were responsible for these expenses under New York law, which he is not. The fees incurred for those tasks are unreasonable and should be substantially reduced. For these reasons and the reasons set forth herein, the court should deny the respondents the ACL's motion. So the background is we knew he brought the lawsuit. We knew why, the op-ed in the Washington Post. We knew already from Eric George, her attorney, how involved the ACLU was in preparing this op-ed. So we're moving on to the subpoenas. Based on the foregoing information, Mr. Depp sought the issuance of the subpoenas, which is for documents and deposition to the ACLU and 2 of its employees, Ben Wisner and Anthony Romero, and together with an ACLU Foundation and Mr. Wisner, the ACL witnesses of ACLU. On February 4th, 2021, Virginia court issued the subpoenas to the ACLU. After the subpoenas were served upon them, they objected to the subpoenas, and Mr. Depp moved to compel compliance here in New York. In July 2021, the court granted Mr. Depp's motion in part and ordered nearly full compliance of the 6 subpoenas. He went, as I said, 23 out of the 24 points, I think it was. The only thing he wasn't allowed to have is information regarding her being an ambassador. Ultimately, the ACLU produced approximately 1,900 documents in response to the subpoenas. ACL provided a log of documents that had been withheld or redacted based on privilege. The privilege log included over 400 documents, approximately 160 of which asserted a common interest privilege or communication between ACLU's counsel and Ms. Heard's counsel. On November 8th, Mr. Depp's counsel emailed respondents' counsel, ACL's counsel, challenging the assertion of the common interest privilege over communications between ACLU's counsel and Ms. Heard's. Remember, ACLU was not being sued by Mr. Depp, so there shouldn't be a common interest. On December 21st, ACLU counsel sent Mr. Depp's counsel a letter requesting reimbursement for the $85,000 plus document expenses over $86,000 in costs. The $85,000, which are the legal fees requested by ACLU, consist of 38.7 hours billed by various people, and they break that down, and we saw that chart. As reflected in the attorney timekeeping records submitted in support of the motion, respondents are seeking reimbursement of attorney's fees associated with reviewing and determining collected documents for both privilege and relevance and preparing a privilege log. The argument is that the ACLU is not entitled to reimbursement of its attorney's fees associated with preparation of the document and the privilege log. And they cite law. While the rule does provide for reimbursement of reasonable production expenses of a non-party, respondents are not entitled to reimbursement of attorney's fees for time spent determining which documents to withhold on the basis of privilege or relevancy. And that's cited in these cases where attorney's fees were declined. This is precisely the type of work for which ACLU seek reimbursement of attorney's fees, detailing a review of materially higher number of documents with a higher proportion of non-responsive documents, increasing attorney review time. And that significant attorney time was required to review responsive documents for privilege and a privilege log. Attorney's fees associated with the document production and privilege log should, accordingly, not be included in the calculation of reasonable production expenses. None of the authorities cited by ACLU in their motion support their request for over $85,000 in attorney's fees. ACLU also cited another case for the position that they seek reimbursement for attorney time spent reviewing documents for response and privilege, as well as preparing their privilege log. But that is not what the court held up. The court found only the reasonable production expenses can include the cost of locating documents, reviewing for privilege, and producing documents. The court did not hold that the non-party was entitled to attorney's fees associated with the relevance and privilege review of the documents, but just encouraged the parties to agree upon a reasonable scope, schedule, and cost for the production. She cites another case. The court acknowledged that there is authority indicating that such expenses may also cover production-related costs, including attorney's fees to a non-party for costs incurred in complying with a subpoena, but did not actually award any attorney's fees in that case. The court held that the attorney's fees and other expenses incurred must be reasonable, and because of the lack of detailed documentation, the reasonableness of the legal fees and e-discovery vendor expenses cannot now be determined, and this issue will be referred to the special referee, which is, we know, like a discovery referee that they had in Virginia. It'd be a different one. Finally, as set forth above in that case, the court expressly declined the award of attorney's fees associated with time spent determining which documents to withhold on the basis of privilege or relevancy. As set forth in that case, reimbursement of substantial production expenses, including attorney's fees, is simply not appropriate in the circumstances present here. Like the third party in that case, none of the respondents' substantial rights are implicated by the outcome of Mr. Depp's defamation suit against Ms. Heard, and ACLU share a close relationship with the defendant, Ms. Heard. Denying a non-party's request for reimbursement in part where the non-party did not have any substantial rights involved and given its relationship with the defendants in the action. Respondents, the ACLU, should be limited to recovering only the $1,000 in costs associated with production of documents only. The requests or the expenses are just unreasonable, even if this court were to find, which it should not, that the ACLU is entitled to reimbursement of attorney's fees associated with the production of documents and a privilege log. Mr. Depp should only be required to reimburse reasonable expenses. The amount of fees requested by respondents, ACLU, is grossly excessive and inappropriate. Accordingly, the respondents seek reimbursement for roughly 120 hours of work for two associates, billing at $500 and $800 per hour, the review of 7,000 documents, and production of only 2,000 documents. The rates charged by the senior and junior associate are above market, and Mr. Depp should not be required to pay for respondent's choice of attorneys that charge top of the market rates. And just to note that, reminding the ACLU assisted Ms. Heard in drafting the op-ed, which is the subject of Mr. Depp's defamation suit, received substantial pledges from Ms. Heard, and as evidenced by the privilege log, this is interesting, respondents were coordinating and assisting Ms. Heard in litigating Mr. Depp's defamation suit, as we all suspected. ACLU are seeking reimbursement for time spent reviewing documents for privilege, implementing privilege redactions, and preparing a privilege log. But much of this time appears to have been spent improperly withholding, redacting, and or logging communications between ACLU's counsel and Ms. Heard's counsel that are not privileged. Mr. Depp should not be required to foot the bill for the time and fees associated with respondents improperly holding material responsive to the subpoenas as privilege. For all these reasons, Mr. Depp is ordered to reimburse any. For all these reasons, if Mr. Depp is ordered to reimburse any attorney's fees associated with the document production and the privilege log, then reimbursable fees should be reduced significantly to account for the unreasonable amount of time billed, unreasonable rates charged, and the expenses associated with the respondents' improper assertion of privilege over communication with Ms. Heard. For the following reasons, the court should deny the respondent's motion and order Mr. Depp to defray only the $1,000 in costs incurred in the ACLU, and if deemed appropriate, only the reasonable costs for production. So another note, as the parties asserting the privilege, the ACLU had the burden of demonstrating their communications with Ms. Heard's counsel is protected by the common interest privilege. Under New York law, the common interest privilege only applies to communications concerning a common legal interest among the parties to the communications, meaning that both parties are communicating in connection with their shared legal interests in anticipated or pending litigation. Respondents have not and cannot meet that burden showing this common legal interest. Most, if not all, of the withheld communication between respondents and Ms. Heard's advisors occurred after Mr. Depp has sued Ms. Heard, but not the ACLU. He did not sue the ACLU, and there's no indication that the ACLU was ever anticipated that Mr. Depp would bring the ACLU into the defamation suit against Ms. Heard as the co-defendant. So that pretty much sums it up. Let me see if I can bring up the privilege log. All right, so here I'm going to bring up the privilege log. I'm not going to go over it. I'm going to just zoom in a little bit of it so you can see. But we've got emails, a lot of emails, some Word documents. Let's see if I can get this here. Because the important point is the from and to, and we're going to see Elaine, Adam, her lawyers. So they, I'm not going to go through the whole thing, but they're claiming attorney-client privileges between them, and that's exactly what Jessica was pointing out. Here we got Adam and Elaine. So they're here quite a bit. There are all kinds of emails and Elaine and Adam. So they were clearly involved in her legal strategy. So the hearing is set for June 15th, 9:30 in the morning. And this judge has been pretty good about rolling over answers pretty quick. So we'll see how much Johnny's going to have to pay. I think it's a shame, but it's a standard procedure, just not at the highest rates ever conceived. Anyway, so that's all I have for today. I will update you with this, and I hope you enjoyed this, and trying to keep them short and simple and not too terribly dry, although court documents are pretty dry. Thanks for tuning in, guys.